The case advanced by the appellant, if I could just draw the court's attention to it, is at paragraph 83, the appellant's case, which is at page MS 46, and it says the following submissions address the appellant's contentions that the Court of Appeal was wrong to conclude that when applying paragraph 90, a judgment on the visual dimension of openness is required to be exercised as a matter of law. 2, applying the correct test, the visual impact of the core extension was not obviously material to an assessment of harm to openness on the facts of this case. 3, reading the officer's report fairly, it's wrong to find that the visual impact of the development on the greenbelt was ignored. Now, it's that third one. If one turns to paragraph 102, one sees the way it's put, that, page 52, in any event, for all the reasons above at paragraph 100, which demonstrate the extensive focus on visual and landscape issues more broadly, and given that, the officer concluded not only there would be no harm to the openness of the green belt, but there would also be no harm to its character. The proposed development had a lengthy planning history. Members would have had significant local knowledge of the site and the greenbelt area in question. Members were shown photographs of the site at the committee presentation in the context of its visual impact. Samuel Smith's objection on visual grounds were highlighted to members in the officer's report. One member objected to the grant of planning permission on the grounds of the principal landscape architect's concerns about landscape and visual impact. Officers and committee members were fully aware of the likely visual impacts of the proposal when exercising their planning judgment on openness in the greenbelt. Only an over-legalistic and exegetic analysis of the officer's report leads to the opposite conclusion. Now, and if you just turn, just for avoidance of doubt, to 100, that has what are said to be, applies the Euro-per-oil approach. The appellant submits on the facts of the case, visual impact on the greenbelt was plainly not an obvious material factor to consider in the greenbelt where, and then it gives a number of reasons why. But none of those reasons, none of the paragraphs I've just read pray in aid the paragraphs which are set out in the officer's report from 7.122 to 7.126, or indeed in any other part of the section on greenbelt. And so it is a surprising contention, to say the least, that it's now suggested for the very first time this morning that the answer to this is in fact found in those paragraphs. The suggestion that 7.122 should be taken to implicitly include visual impact simply because it's not excluded, that was my learned friend Miss Ogley's contention, is, in my respectful submission, untenable in light of two factors. Firstly, at the time of the committee report and the time of the committee's decision, the jurisprudential position, the legal position was as per Mr. Justice Green in Timmins. In other words, if the committee were saying to themselves, well, we don't need to take visual impact considerations into account, then it would have been because Mr. Justice Green in Timmins says we don't, then that might have been an explanation. Incidentally, I'll come on shortly, perhaps I could even deal with now, the fact that the reason Mr. Justice Higginbottom made the assumption that they were relying on Mr. Justice Green in Timmins is because it was Darrington's case, and put forward by Darrington, the reference, please, that visual impact was not a relevant consideration. And of course, Mr. Vendy took issue with that in one of his letters. So that, I think, is why Mr. Justice Higginbottom made that assumption. But if you go to our case at page 125, paragraph 33, in his letter of the 19th of August, Mr. Vendy returned to the issue of openness when responding to the revised planning statement that had been submitted by Darrington. On page 4, Mr. Vendy stated as follows: paragraph 6.2 of the planning statement references case law in support of the position that mineral development in the Greenbelt will not harm openness. And it goes on. The applicant's reference to the Heath and Hampstead decision appears to seek support for the idea that the assessment of openness cannot take into account visual impact. Given that openness is defined as the absence of development, the visual impact of a proposal is a key component of the assessment of the impact upon the Greenbelt purposes and openness, and other interpretation of the policy in this regard would appear to be erroneous. And then 34, Mr. Vendy continued by expressing concern about Darrington's approach. He said, this is particularly the case given the apparent exclusion of the visual impact of the proposal from the applicant's assessment. It's important that the difference between landscape and visual assessment of the proposal and the components of the assessment of the proposal impact on openness, the proposal's impact on openness are properly understood by the council and officers.
So, as I understand, your clients were positively asserting that visual impact was a relevant component of openness.
They were asserting that, and it was...
So why should, when we come to read the officer's report, why don't we read it against the background that that was a feature of the argument being presented?
Well, it wasn't presented in the officer's report like that.
I thought that we were shown that a passage in the officer's report which drew attention to the consultation response from Samuel Smith.
There was a... we can go through the report in a bit of detail in a moment.
All right.
But it was not... I will go through it, but it was not presented on the basis. First of all, they didn't even mention in the relevant part that Samuel Smith objected on Greenbelt grounds, as we'll see. But we'll come on to that in a moment.
Yes, thank you.
Sorry, your point about this is that it was, Mr. Vendy does take a point about the legal relevance of visual impact. So that was before the council.
Yeah.
But you're not saying that the council was advised that he was wrong or anything like that, are you?
No, well, Mr. Vendy writes to the council saying, look, the applicants for planning permission, Darrington, have got it all wrong.
Yes.
About...
And he says that's a legal position.
And they seem to be relying on Heath and Hampstead.
But I mean, the council don't sort of get bogged down in the case law. They don't
get bogged down in it. But I'm just focusing on the submission by my learned friend Miss Ogley. And if it is this case, if I've understood it correctly, it seems to be, if I may say so, an extraordinary submission, that because there is no reference in that paragraph saying that visual impact can't be taken into account, then it clearly is implicit that it can. And it should be taken, it has to go further, and she say that it should be taken into account.
But what was Mr. Vendy saying was the aspect of visual impact which was crucially important to be taken into account? I mean, he's making a legal point here, but was he saying there was some visual impact point which was specifically relevant to openness?
Well, if you turn to his letter, my lord, it's... The first letter, I think, is at page 489, and he deals with, he makes a comment about Greenbelt policy at 490, saying, I note that the Greenbelt policies that apply to the application site are referred to as landscape policies. This is manifestly wrong and demonstrates a fundamental misunderstanding at the heart of the landscape and visual assessment of the proposals. He then goes on to deal with Greenbelt policy at 492 to 493, and he explains at the top of 493, in the first instance, it's clear that the proposal will harm the key characteristics of the Greenbelt, its openness. The application proposes a substantial and large area of excavation that will be visible from a number of public and private vantage points. Of course, the assessment of a proposal's impact upon the openness is not only visual, but also need to consider the levels of activity, impacts on the character of the area and other harms such as noise, natural features and surroundings, and the general characteristics of an open native environment. The test, of course, is nothing to do with the assessment of environmental impact and the harm, mitigation and resultant environment that's been examined and analysed in the environmental statement, but a consideration of qualities and features of the Greenbelt. And then it goes on to look at the purposes of including land in the Greenbelt and what harm he says would flow from that. But don't take Mr. Vendy's word for the issue of what harm there would be, because one can see that from the officer's report itself. And before we just do that, could I just deal with one short point which is relevant to this, and that is to answer the question of the court this morning as to what the screening buns were and where they are. And could I invite you to the supplemental volume that was...
So just before we move on from this letter, I mean, might it not be said that the officer's report read as a whole does address these detriments which are being put forward by Samuel Smith in this letter?
Lord, I, with respect, no, they don't. And we will go through, as I say, I will address this. We can go through the report with a fine-toothed comb, but we won't find where these points are addressed in the report to committee. On the question of openness, I wanted to draw your attention to the issue of the buns, because this is perhaps the most important, obvious aspect of a distinction between, on the one hand, something that might be good in landscape terms and good in visual terms, namely screening the development from view, but by contrast is harmful in Greenbelt terms because it affects openness. And if you turn to the supplementary and in particular pages 99 through to 104, and regrettably these are in black and white, certainly in our bundles, what one needs to see is a plan which shows where these screening buns would be, particularly around the south and the east of the site. And one can see why they have to be included in the scheme, and that is because of the two residential properties, Warren Cottage and Warren House Farm, immediately to the south of the site.
I'm so sorry, which page are you?
I'm in the supplementary bundle, and it's at page 99, and they're the same plans, but they
I see, yes,
they
thank you.
show different phases going through to 104. And that bund is this yellow line down here, which I'm just pointing to.
Yes.
And goes round the south and the east of the site. Now, just putting that down for one side, we'll come back to that bundle in a moment, but just to bear in mind why that is important, because if we go to the officer's report, one of at paragraph 7.42 on page 358, one of the points which was identified, and I have to take my lords through some parts of this officer's report in a little bit of detail later, but I just want to deal with this point now. And this is the paragraph that Mr. Kalinsky only read half of, although he came back to give a little bit more of an explanation about it later in his submissions this morning. 7.42, but the bit that's important, he didn't read, was, however, the consultation response also notes that the proposed bunding and planting could help residents during the operational period, but in the long term could cut off the long-distance views that are currently obtained. Now that is, of course, an explanation of why something might be helpful in landscape terms, in terms of screening the views. But it also, the other side of that particular coin is that it is the paradigm of openness being severely affected, because open views across the site are removed by these bunds and screening and planting.
So it's Warren Cottage and Warren House Farm in particular are affected.
That's right? Precisely right, which are owned by my clients, I should add. Sorry.
And as I think I recall somewhere, it's about 30 metres, is it? From
it
the
is
boundary
indeed, 30
to the
metres
bunds.
from the bunds.
Yeah.
Now, and whilst we have that bundle, can I just ask you to look at other aspects, because we're going to come on to the description which Mr. Lord Justice Lindblom took great pains to look at in a very fair way in the judgment. But just to understand the nature and scale of this development, if you turn to page 97, you'll see in red the application site, and immediately to the north is the existing quarry. Remember that the proposal is for 25% increase in the size of the existing quarry, some 6 hectares, and producing some 2 million tonnes of aggregate over a 7-year period. And if one turns to page 110, one can see the plant that is the existing plant, the processing plant that's included, and then one can see what a restoration looks like, because we'll come on to this in a moment, at page 111, where one sees sheer cliffs of rock and effectively land carved out. So the natural contours of the land are changed forever. And then there are further similar pictures. 112 gives another picture of the restored eastern arm of the quarry. And 115 gives views across the southern end of the quarry towards remaining reserves. So one can immediately see the very significant impact. But bearing that in mind, then turn to the officer's report. I'm
so sorry, I'm just trying to follow this. When you say the significant impact, these are photos of what's there at the moment, aren't they?
Yes, the significant, they are there, those are exactly photographs of what is there at the moment. Yes.
Right.
Yeah, but they give an indication of restoration, for example.
I mean, there,
And there was no other material. It said, well, members would have been perfectly aware of what the development, well, the effect of the development. But yes, and they would be aware of the effect of the development by reference to these photographs.
But isn't this giving an indication of what the view is from the cottage and the farm already?
No.
No?
No, the cottage, there are, in fact, I don't think there are any photographs of what one can see from the cottage at the moment, but in fact, the cottage, there are just green fields in front of the cottage.
Yeah, but
Those
I mean, if one looks at page 97,
Yeah.
the farm and the cottage, I think of the sort of slightly darker thing at the bottom of the...
Yeah.
So aren't they looking across a field and then into the quarry?
No, they're not looking into the quarry because they're too far away to look into it. The quarry is... I mean,
But they can't see it.
They can't see into it.
but
Is that really right?
Yeah. Are there pictures of any buns that you can show? Are there buns on the old quarry?
No, there are no...
Buns. These mounds of earth to
No.
shield the houses from the quarry.
No, there aren't, my lord.
But I mean, what strikes me looking at this, it might be said to be an illustration of the difference between openness and visual impact. I mean, this is not very beautiful from a visual impact point of view, but it's very open. I mean, arguably, there's nothing much more open than a big hole like this.
Well, no, but we're...
So I'm not sure how this is helping the argument, really.
I'm focusing on the buns, and
The bun.
we can't see the buns. There are no pictures of those because I don't think there are any buns actually screening that development as it exists. But
You're saying what might otherwise be appropriate development was made inappropriate because you put up some buns to try and stop individual cottages.
I think all the court can do is just take two things from this. Firstly, the council's own landscape officer was raising concerns about this. So this hasn't come from my clients. This is a genuine assessment by the council's own landscape.
No, I mean, it obviously has an effect on the view.
Yes, and secondly, this is always the danger of exercises of this kind, but plainly it's not for the court to arrogate to itself the decision as to what would or would not have been appropriate development. But what we say should have happened is that the members of the council should have been clearly advised in terms in the section on Greenbelt that visual impact was a relevant consideration for them to take into account, and that there could be, our concerns about under landscape, there could be an adverse effect on the openness of the Greenbelt. And just on that, as a matter of law, as to the nature upon which one, the degree of exactitude that there should be in an officer's report to committee, I entirely accept from the court that it's that a degree of benevolence should be used when reading these reports to committee. As I'll point out shortly, Lord Justice Lindblom was entirely aware of that as well. I mean, not least because he gave the judgment in Mansell and Tonbridge and Malling, which is at tab 27 of the second bundle of authorities. And the reference I would draw your attention to is at page 1193, where he set out at paragraph 42 the principles, 1193, where he set out the principles which the court will act when criticism is made of a planning officer's report to committee. He says, 2, the principles are not complicated. Planning officers' reports to committee are not to be read with undue rigour, but with reasonable benevolence, and bearing in mind that they are written for councillors with local knowledge, referring to Baroness Hale's judgment in Morge. Unless there's evidence to suggest otherwise, it may reasonably be assumed that if members followed the officer's recommendation, they did so on the basis of the advice that he or she gave. See the judgment of Lord Justice Lewison in Palmer and Hertfordshire Council. The question of the court will always be whether, on a fair reading of the report as a whole, the officer has materially misled the members on a matter bearing upon their decision, and the error has gone uncorrected before the decision was made. Minor or inconsequential errors may be excused. It's only if the advice in the officer's report is such as to misdirect the members in a material way, so that but for the flawed advice it was given, the committee's decision would or might have been different, that the court will be able to conclude that the decision itself was rendered unlawful by that advice. Now, just one other reference. He goes on over the page, and he says that where the line is drawn between an officer's advice that's significantly or serious misleading in a material way, and advice that's misleading but not significantly so, will always depend on the context and circumstances. And then he gives one example, and then just to go over the page, there will be others where the officer has simply failed to deal with a matter on which the committee ought to receive explicit advice if the local planning authority is to be seen to have performed its decision-making duties in accordance with the law. And he recites a case of Williams and Paris County Council. Now, I have to submit to the court that in circumstances where highly experienced leading counsel representing the council submit to the High Court and then the Court of Appeal and then to this court in its application for permission to appeal, that there was no need to consider visual impact when considering openness, and to accept also, as she did, that visual impact was not considered in the relevant paragraphs under Greenbelt. It goes beyond the bounds of credulity to suggest that that a fair reading of that report from that experienced counsel, and indeed the judges that went with it, would indicate that they're not being unduly benevolent. And in concluding, as they did, that visual impact was not considered as part of the assessment of openness.
Well, we'll have to make our own assessment of that, won't we? We can read the report for ourselves.
My lady, yes. Could I just turn to where the Lord Justice Lindblom, the Court of Appeal, dealt with these issues, please? Because we haven't yet visited these parts of the judgment. Paragraph 11 of the Court of Appeal's judgment, which is starts at page 237. Lord Justice Lindblom went through the officer's report to committee in detail, particularly containing the observations about the likely visual effects of the development. And and he cross-references every relevant paragraph in the report. I didn't read it out, it's obviously there for the court to read, but it is relevant when we come to it later in his judgment, because he deals with the question of visual impact and its effect on openness, firstly by reference to paragraph 40 by reference to paragraph 7.122 and paragraph 45 of his judgment, page 249, where he says that it's paragraph 7.122 that one must look, at least in the first place, to see whether the officer considered the relevance of visual impact to the effect of this development on the openness of the greenbelt. Did she confront this question and bring the committee's attention to it? I do not think she did. Now, just pausing there for a moment, had he already considered what the effects would be that would be potentially relevant to that consideration? The answer to that is obviously yes, in paragraph 42 and 43 of the judgment. And 42 is, I'm going to read both if I may. The proposed development was a substantial extension to a large existing quarry with a lengthy period of working and restoration, as the principal landscape architect recognised in her response to consultation, and the officer acknowledged without dissent in her report, there would be permanent change to the character of the landscape, giving the references. The quality of the locally important landscape area as a whole would be compromised. The exposed face of the extended quarry would be visible as that of the existing quarry, if not more so. Long-distance views could be cut off by the proposed bunding and planting. Agricultural land would ultimately be replaced by a deep, lower-level landscape of grassland. The character and quality of the landscape would be permanently changed, and the impact cannot be described as neutral. Concluding her assessment of landscape impact, the officer was satisfied that the proposed screening could protect the environment and residential receptors from potential landscape and visual impacts, and that with the proposed mitigation measures, the development would comply with national and local policy. That assessment did not deal with the likely effects of the development on the openness of the greenbelt, either as such, either as spatial or visual. It does show, however, that there would likely be, or at least could be, effects on openness in both respects, including the closing off of long-distance views by the bunding and planting that would screen the working. See paragraph 4111 of the officer's report. The officer's conclusion overall in paragraph 7.47 was in effect that the proposed screening would be effective mitigation without which the development would not be acceptable. But this was not followed with any discussion of the harmful effects that the screening measures themselves might have on the openness of the greenbelt. And those conclusions are unimpeachable in my submission. But he didn't stop there, because at paragraph 46, he went on, having looked at paragraph 7.122, he said one must not divorce paragraph 7.122 from its context. The report must be read fairly as a whole. The question arises, therefore, did the officer address the visual impact of the development on the openness of the greenbelt in the remaining paragraphs of this part of her report or elsewhere? I do not think she did. Her consideration of the effects of the development on the purposes of including land in the greenbelt in paragraphs 7.123 to 125 is unexceptionable in itself. However, she did not, in these three paragraphs, revisit the question of harm to the openness of the greenbelt, either in spatial or in visual terms. The conclusion to this part of the report in paragraph 7.126 is that the character and openness of the greenbelt would not be materially harmed by the development, a conclusion repeated in paragraph 8.5, and that the proposal would therefore comply with policy SP3 and policy SP13 of the local plan and the framework. But I cannot accept that this conclusion overcomes the lack of consideration of visual impacts on openness in the preceding paragraphs. It seems to treat character as a concept distinct from openness, even if these two concepts can be seen as related to each other, and however wide the concept of character may be, there's no suggestion here that the officer was now providing a conclusion different from that in 7122 or additional to it. And the same may be said of the officer's earlier discussion of landscape impact in paras 7.41 to 7.7. Her assessment and conclusions in that part of the report are not imported into para 122 or cross-referenced to as lending support to her conclusion there. As the judge said in paragraph 26 of his judgment, the office's conclusion in paragraph 7.47 was that with the proposed mitigation, the potential adverse landscape and visual impact would be acceptable in the sense that it was outweighed by other factors such as the social and economic benefits of continued mineral extraction on site, a point expressly minuted as having been made by the head of planning services at the 9th of February committee meeting. Now, just pausing there, and just picking up one other point of Mr. Kalinski's, that it seems to, in our submission, it frankly is a point that goes nowhere. That the minutes and what the Mr. Justice Higginbottom, as he was, and Lord Justice Limblom referred to there, is in fact a reference on page 404 of the minutes where it's recorded, and this obviously is part of the discussion. It's not in the report, but it's part of the discussion that followed. Nevertheless, the representative, that's the last bullet point on page 404, nevertheless, the representative of the head of planning services advised that a planning balancing act is required between the impact of the proposed development on the locally important landscape area and the social and economic benefits of continued mineral extraction on site. So that's why both Mr. Justice Higginbottom and Lord Justice Limblom, reading this benevolently and fairly, thought that the committee were effectively importing issues of balance into their benefits against harm into their assessment of the effects in landscape terms.
But I'm just on the minute. That is in a separate section from impact on the greenbelt, which we see on the facing page.
Yes, yes, it is. It certainly. I don't suggest for a moment that that balance was used in the greenbelt section. It was used to, and that's our. This, in fact, our point is that that balancing aspect was used to balance against the harm from the landscape. That the economic benefits were balanced against the harm of the flow from the landscape. That's the way it was considered by the officers and members.
Okay, can I just ask one last question about the bunding?
Yeah.
I rather had the impression that the bunding was going to be there while it was a working quarry, because one sees from the plans that you showed us that you've got the incline going down, which is presumably for the lorries to take the aggregate out and so on. So the bunding would screen the cottage and the farm from noise and the visible activity. Is there a proposal that it will be removed when the quarry ceases working, or that just remains an open question as to what the DRMP would do?
Yes, there isn't any explanation as to whether it would be removed. There's no condition which requires it to be removed, but I think it does more than just, if I may say so, screen the Hall Road. It is also screening the sheer cliffs and the workings, and it's there, as you can see, from year one.
Might I draw your attention to 742 of the document, where it may be said there's a suggestion that the bunds or the bunding would cut off the long distance views.
Yes.
It's rather suggested, or might maybe said to suggest, that actually the bunding is going to be permanent.
Yes.
Yes, as in long term.
Yes, but in the long term could cut off the long distance. Yes, it does. It does say that.
Yes, thank you.
So, if I may respectfully suggest, Mr. Kalinski's incorrect in saying that the court below transgressed into failing to read the report with the proper amount of benevolence. as it should be accorded. The court bent over backwards to go through all the relevant parts of the committee report and to see whether or not there was any suggestion that visual impact was considered as part of openness. And if I may say so, it's because of that careful analysis that the concession was made in the High Court and the Court of Appeal that visual impact was not taken into account when assessing openness. Can I see with the restoration scheme?
Just before you go there, I just want to understand, what is it, in addition to the bund and its effect on the two houses, that you say the visual impact in relation to the green belt will be different from visual impact in relation to what the planning officer discussed between 737 and 747? What is the complaint?
If one turns to the photographs which I've already referred to, I mean, one can turn to any of those photographs and say that those demonstrate visual impact, which clearly identify development which affect the openness of the green belt. They affect, if I was permitted to borrow the words of Lord Sales,
So you're saying because it shows development of this nature, that of itself affects the openness?
yes, exactly. It affects the eye and the spirit. It does the opposite of relieving the eye and the spirit from the prospect of unrelenting urban sprawl.
Well, I mean, that's picking up my colleague Lord Sales's gloss on openness in his judgment.
It is.
I was just wondering quite far away from the concept.
I think one can say, is the effect there a spatial effect or a visual effect, or is it both? And I think it's both, but I'm particularly focusing on the visual effect that is obvious from that form of development. Obviously, and I take Lord Sales's point, that isn't the actual development, but it's what it would look like. And in terms of the planning officer's own assessment, I mean, they made clear what the effect would be, if one goes back to page 358, as to what the effect would be in terms of the landscape impacts, para 7.41. In terms of potential landscape impacts from the proposal, the County Planning Authority's principal landscape architect notes that although the restored landscape may well be of considerable landscape and visual interest in itself, the quality of the locally important landscape area as a whole would be compromised. This response should also be, then it goes on to say, in 7.42, so the part of the paragraph which he did read, the quarry extension would still result in an exposed face close to the skyline, which is likely to be as visible as it is at present, if not more.
Thank you.
And thirdly, 7.44, the County Planning Authority's principal landscape architect confirms that mitigation and restoration measures would soften the landscape and visual impacts, and the nature conservation value of the new landscape would be much greater, but landscape character and quality would be permanently changed, so the impact cannot be described as neutral.
Your submission is that when it came to 7122 and the paragraphs that follow, those considerations were not in the officer's mind?
No, they weren't. Those were simply looking in fact, 7.123, it starts to simply look at a different point altogether, the purposes of the second part of the test, the purposes of the green belt. And it's only so for example, it says in terms 7.123, in terms of whether the proposed development does not conflict with the purposes of including land within the green belt. The proposed quarrying operations are not and the same in 124 and 125.
The 126 specifically refers to proposed restoration of.
And the restoration scheme to which I was just about to come.
Yes.
And that, so this is the point that's been made for the first time today, and it said that the restoration scheme indicates that the committee were advised to consider visual effects in terms of openness. First of all, the restoration scheme didn't exist. It was a proposal is a proposal in the Section 106 agreement to provide a restoration scheme within a year of the grant of planning permission. I can't tell the court whether or not, in fact, it's been presented. I imagine there's probably been a letter or a side letter to say, look, whilst all this challenge is going on, we're not going to do that. But it was not before the committee. The restoration scheme wasn't before the committee, and that's why it says at 7.126 the restoration scheme is to be designed and submitted as part of a Section 106 agreement.
Can you give us the Section 126 page reference? Just for
Yes, my lord, it's...
Sorry, Section 106.
It starts at page 56. Oh, sorry, did you want in the officer's report?
The 106
No,
letter.
sorry, I meant Section 106.
Yes.
It's the agreement, just for our reference.
Yeah, so it starts at 56, and the reference to the detailed... Oh, I'm sorry, thank you. I've got you giving you the wrong reference. It's page 70. Page 70. And which is the completed agreement, and the reference to the detailed restoration management plan is at 78. And it's instructive in itself, this 106, because it itself accepts in terms the harm that flows from this development in paragraph 1D, which refers, it's the DRMP shall include the following overarching aims and objectives. D, to minimise the visual impact of the site and integrate it as far as possible with the surrounding countryside in the earlier phases of restoration works undertaken at Jackdaw Quarry.
Could you give me the reference for that page reference?
I'm sorry, my lord, it's page 78.
78, thank you. But is your submission that it was not appropriate then to consider the proposed development in the context of this analysis in 7126? The proposed redevelopment, I beg your pardon.
My
restoration.
Submission, I think my submission is that it is possibly narrower than that, which is that it cannot be suggested that members of the committee were being advised to have regard to the visual impacts of this development on the openness of the Greenbelt simply by reference to the restoration scheme. And it's impossible to say whether that restoration scheme, what the terms of it would be, but it's envisaged that there would be harm flowing.
It's envisaged that there would be visual impact.
It is.
Which ought to be minimised.
Exactly. Yeah. And that's not preserving the openness of the Greenbelt. Just staying, if I may, with the restoration scheme, the restorations doesn't deal with the impact of the screening mounds. It doesn't consider the wider impact of the development on the openness of the greenbelt. But what it does do, as I say, is it does envisage a visual impact which would be minimised as far as possible. So could I just bring together where we have, where the where we are at this stage in the argument. First of all, it is not in dispute that the council was legally obliged to have regard to the Greenbelt policy in the framework, and there is no dispute that the council had regard to visual impact considerations in the assessment of landscape impact at 7.37 to 7.47, insofar as they bore on the issue of landscape. I would have submitted that it could not be in dispute, and is not in dispute, that the officer did not take visual impact into account when considering the likely effect of the development on the openness of the Greenbelt, but that submission has changed just as my Lennon Friends case has. But I have to say that it's a submission which is manifestly ill-founded. And I should also add that there hasn't been a respondent's notice or any other suggestion that the judges were wrong to so conclude. It's a remarkable feature of this case, given that there was a threshold question of whether the development was appropriate or inappropriate, that openness is only considered in effectively one paragraph in this long officer's report at paragraph 7.122. But it is also a remarkable feature that the report fails to understand and offer to the members advice which explains the fundamental difference between a landscape impact and an effect on openness.
Yeah.
As to the meaning of openness, the Court of Appeal has now twice considered its meaning, both in Turner, and I do submit that that the ratio of Turner includes paragraph 26, where Mr. Justice Timmins' Mr. Justice Green's, sorry, Mr. Justice Green's two propositions were rejected. That does bring me to some.
The first problem, sorry.
Rejected. It was just the inevitable connection between the two that was rejected.
I mean, you're submitting, as I understand it, there's a conceptual difference between openness and visual impact. That's what you were saying a moment ago, and that wasn't properly understood by the officers. No.
I mean, it's the appellant.
I mean, what was wrong, I think everyone seems to agree now with respect to Justice Green, was to suggest that you couldn't consider visual impact, that it was simply irrelevant. Whereas I think everyone now agrees that it can be relevant, but that's obviously a matter of planning judgment.
Yeah. It's the appellant who says there is a conceptual distinction between openness and visual impact. That's just to confuse the approach.
I mean, there is a difference.
I mean, they're obviously, as you say, different words.
One is, well, also that they're serving different purposes in the circular. That's obvious.
Visual impact is part and parcel, as is spatial.
You know, because we've seen time and again, the PPGs and the National Guidance says openness is a function of the green belt and is not necessarily dependent upon visual quality. They're two different things, but clearly, as a matter of common sense, visual impact can be a factor in considering openness, and that's
Well-
I thought we were all agreed on that.
Well, if we are all
The only issue is to what extent that was taken into account by this officer in this report.
well,
And we've been over that many times.
if that is a matter of agreement, that visual impact is an integral part, as it's
It
called.
can be relevant.
Yes, well,
It's all
it's obviously...
It's a factor or an aspect, or can be,
Yes.
in relation to openness.
As Lord Justice Lindblom himself recognised, it won't be in every case.
But I mean, why do we need all these authorities to tell us something which is perfectly plain from the NPPF, and it's a matter of common sense? That's all, I know I blame myself because some of these judgments are mine, but but looking through them, one thinks, oh gosh, where did we all go wrong?
Well, as far as I can happily proceed on the basis that visual impact is, like spatial impact, a component part of openness. But to talk about there being a conceptual distinction between openness and visual impact is just extremely unhelpful. I mean, it's comparing apples with pears. And of course, it won't be in every case that one considers visual impact as a determinative factor. So, for example...
I'm just considering the visual impact of raising the blinds and their effect on the openness of these premises.
Indeed.
Does that not illustrate?
And standing in the coffee shop, one gets a very good impression of a beneficial spatial effect and a beneficial visual effect. But you won't necessarily have a visual effect in every case, and you won't necessarily have a spatial effect in every case. And Lord Justice Lindblom didn't say differently to that. Just, I mean, where he dealt with this. Where he dealt with this at 37, the concept of the openness of the green belt is not defined in paragraph 19, nor is it defined elsewhere in the framework. But I agree with Lord Justice Sales' observation in Turner to the effect that the concept of openness, as it's used in both paragraphs 89 and 90, must take its meaning from the specific context in which it falls to be applied under the policies in those two paragraphs. Different factors are capable of being relevant to the concept when it's applied to the particular facts of a case. My Lord is completely right that there's a huge amount of effort that's gone in this case to looking at Creed NZ factors. I mean, talk about a legalistic approach. It took the council's approach was effectively to try and sideline visual impact as some other material consideration, nothing to do with openness, which the council weren't obliged to take into account because it wasn't obviously material. But that's wrong for two reasons. Firstly, the statutory requirement, and I need to say no more about this issue if this is the case. The statutory requirement is to have regard to all material considerations and to have regard, and there's it's also accepted that the decision maker should have regard to the policy and the framework. So those are the two requirements of the decision maker. And if you have regard to, in doing that, you have regard to the issue of openness. Openness, by definition, includes spatial impact and visual impact, so you can't just divorce one from the other. And that's really the beginning and end of that particular point. And what Lord Justice Lindblom, the Court of Appeal, went on to say at 38 was that to exclude visual impact as a matter of principle from a consideration of the likely effects of development on the openness of the greenbelt would be artificial and unrealistic. The policy in para 90 doesn't do that. A realistic assessment will often have to include the likely perceived effects on openness, if any, as well as the spatial effects. And he said that in the context of this case, where there's an abundance of evidence, not just in terms of spatial effect, but also visual effect of the harm that would be done to openness. In terms of I'm going to turn, if I may, now to commenting on the council's case as pleaded in its case. At paragraph 87 of the council's case, sorry, I beg your pardon. Could I just start by drawing your attention to paragraph 4 of the council's case? Because that's paragraph 4 on page 20. The Court of Appeal, they say, decided that the appellant had erred in law. In so deciding, the Court of Appeal adopted a legalistic approach to the consideration of openness, and this failed to differentiate between the application of a policy and the legal control of its meaning. Just pausing there, I don't think I need to say any more about that. I mean, the legalistic approach is that of the councils, not the courts. Its approach is also unwelcome in that it tends to obscure the conceptual distinction between openness and visual impact. Again, I mean, it's now completely obvious that that point is just wrong. They're talking about two different things. Openness is the concept and visual impact is the component part, along with spatial. And then further they go on, it would wrongly require defensive justifications to be given for any visual impact in officers' reports, which risks undermining their real purpose as an aid to democratic decision-making and runs counter to well-established guidance as to how the proviso in paragraph 90 of the framework should be applied to work sensibly in practice. My lords, that is a very strange submission, if I may say so. Why should a local authority be adopting a defensive justification when writing about writing a report to its members, and in particular advising its members as to what lawfully should be taken into account when making important judgments as to whether or not the development was appropriate or inappropriate? It is, if I may say so, an entirely legalistic approach to say that one starts from a defensive position. It's not a question of being defensive, it's a question of what is right. Moving through the council's case, could I invite the court to paragraph 87, please? Paragraph 87 is under the heading, Roman 1, on page 46. The Court of Appeal was wrong to find that as a matter of law, an assessment of visual impact is required by paragraph 90 of the framework. As is clear from the paragraph I've just read out of Lord Justice Lindblom's judgment, that is not what Lord Justice Lindblom said. But in any event, if one turns to paragraph 87, they say that Lord Justice Lindblom purported to find an error of law on the basis of Lord Justice Sale's analysis in Turner. However, he did not follow Turner, but went significantly further than Lord Justice Sale's. Lord Justice Lindblom elevated the visual dimension of openness from a matter that is capable of being taken into account as a matter of law to one where an express judgment on the visual dimensions of openness must be exercised as a matter of law. This is both inconsistent with Turner and wrong as a matter of principle. Again, I refer to paragraph 97 of Lord Justice Lindblom's judgment. Paragraph 37 of Lord Justice Lindblom's judgment, where he identified that it will depend on the specific context as to whether visual impact falls to be taken into account. He didn't go any further than the way that Lord Justice Sales put it in Turner. Again, at paragraph 90, it's suggested by my learned friend, the effect, and this is his case at page 47, the effect of this proposition is that the likelihood of or the extent of visual impact on openness of the greenbelt is wrongly elevated to the status of a relevant consideration that a decision maker must consider in every case and would otherwise lead to an error of law. My lords, no. I mean, again, this misunderstands the meaning of openness, and that's why I submitted at the outset of my submissions that the public interest and importance of this case relates and revolves around the meaning of openness. Because once one understands what openness means, both it has a visual dimension and a spatial dimension, then the material consideration is that of having regard to openness. What Mr. Kalinski is saying is, oh, no, you have regard to openness and visual impact. No, it completely misunderstands the nature and the meaning of openness. And that's why we place a great deal of weight in what the court said in Turner, which was that visual impact is an integral part of openness. Sorry, the question of visual impact is implicitly part of the concept of openness. Paragraph 15.
I mean, does it really come to this, in your view, that in your submission, that openness is the absence of any development as assessed both spatially and visually? Is that really what it is?
Yes.
Yes, thank you.
And I can just go a little bit further than that and say that one can conceive of developments which would have an impact on spatial terms but not visual terms. Particularly, I mean, that's a classic Heath and Hampstead type situation. And the other side of the coin, a visual impact but no spatial impact. So, for example, if one had low-rise development which was acceptable in visual terms, but using the same footprint, one erected or sought to erect high-rise development on it that could be seen.
I think if I understood your earlier submissions correctly, those are important aspects, but one might have an interference with openness by, for example, a great deal of noise.
Yes.
So, as I understood your submissions, you wouldn't limit yourself to
I wouldn't limit myself to
the absence of those two features.
I would say it's the absence of. I don't think one can limit oneself to spatial and visual, but it would also be other. And I think I wouldn't go that far as to limit myself in that way. I think I would also include. Just looking at the way it's put by the government in their recent sorry? 136. Oh, thanks. Yes, I mean it could be it could be an activity which generates or a development which generates activity. I'm just trying to think. I mean, I suppose it could include, for example, a use which didn't include any built development at all that could be seen. Yeah, I mean, for example, paintballing in the greenbelt. If that,
We're a long way away from this case.
yes, car parking.
Car parking.
Yes. So it would include uses.
Mr. Village, I'm not quite sure how you would reconcile the answer you gave to my Lord Hodge, that openness is the absence of development assessed spatially and visually, and you said, yes, that's what openness is, with paragraph 90 of the MPPF itself, because that seems to envisage that you can have development of some kind, which is consistent with maintaining openness of the green belt. So I just didn't. I welcome your assistance on how you marry up your answer to my Lord.
Yes, I mean the paragraph 90 identifies, but it's subject to preserving the openness of the green belt and not conflicting with the purpose of including land in the green belt.
Certainly, but the point I'm seeking to put to you is that 90 contemplates that there will be development.
Yes.
And it's a little bit difficult to think of development which doesn't have any spatial or visual impact. I would have thought almost, I can't think of a development that doesn't have one or other of those. And yet it contemplates that development with those effects can be appropriate in the green belt.
Yeah. Well, I think the answer to that is that paragraphs 89 and 90 set out a policy framework of what will be considered to be appropriate or inappropriate development in the green belt. And so, for example, if you look at paragraph 89, that is a policy which regards the construction of new buildings as inappropriate in the green belt, except, and so look at buildings for agriculture and forestry, it is an exception which is entirely unconstrained by condition in this closed list. And the policy therefore assumes, or effectively identifies, a form of development which will be acceptable in the green belt. I mean, that's not to say it won't have an effect on openness and so on. It just identifies that which will be acceptable. It was that form of development that was in play in Lee Valley, in the Lee Valley case, where it was glass houses. And there were some, tens of hectares of development which was considered to be acceptable against that provision. I'm sorry, my lord. Would you? I mean, I'm just trying to. I would like to help my lord.
Yes. Well, I was left slightly perplexed by your response to my Lord Hodge. Lord Hodge, as I noted it, putting to you, is this right? On your approach to openness, openness is the absence of development assessed spatially and visually, to which you said yes.
Yes, I mean,
that seemed like a very sort of bright line type approach. Well, it didn't seem to live with paragraph 90.
No. I think I think I need to qualify it, and I thought I perhaps had done to Lord Kitchen, but I need to qualify it by saying it's not limited to built development, it's the absence of development. So openness is, and it's, I think, said by, in a number of cases, is commonly regarded as being the absence of, openness is regarded as being the absence of development. And that's not just operational development, but also could be a use.
But would the way to reconcile the matter be to recognise that in both 89 and 90, one is accepting that there is development to a degree, but one is looking more generically at the openness of the green belt, rather than looking at it absolutely. I mean, you focus, for example, on the bund and its effect on the two houses in front of it, but it might be suggested that the openness of a green belt is a more generic concept than being concerned with the views from those two houses. And it may well be that those two houses may lose their long distance views without there being any material eating into the openness of the green belt. Something like an assessment of that nature might be required.
Yes, I think, I mean, if I may say so, I would like to say a few words in the time I have about the Europa case, but this I think, is perhaps relevant in that respect. And you had some submissions from Mr. Kalinski about that. I think it's just important to note the limited nature of the Europa case. But in that case, it was an application for an exploratory drill site, and the development was only to last some 18 months, and permission was refused by the county council. And at appeal, the appeal was dismissed on the basis that the proposal wasn't mineral extraction or engineering operations, and therefore didn't fall within the exceptions in Para 90. And the development hadn't been justified by very special circumstances. Mr. Justice Ouseley found that, rejected that case and found that the development clearly was mineral extraction under paragraph 90. And he then had to consider as to whether or not the decision would inevitably have been the same against a simplex test. The case therefore establishes that mineral extraction has a wider meaning than was thought, and that whilst the concept of appropriate development encompasses mineral extraction which preserves the openness of the greenbelt, what's required is an assessment of whether the proposal will preserve openness or not on a fact-specific basis. And I should just pause there to note that the judge didn't make any comment one way or the other as to what the decision would be on a fact-specific basis, whether or not it would preserve the openness of the greenbelt. But he merely said that against simplex, the result wouldn't inevitably have been the same. The mere fact that some development will occur doesn't necessarily mean that openness will be harmed. This says, if I may say so, nothing relevant, let alone of conflict about the requirement to consider visual impact of what's proposed in considering openness. The pragmatic approach of the courts in Europa Oil. And of course, I should just remind the court, the decision was affirmed by the Court of Appeal. Lord Justice Richards agreed with the general thrust of Mr. Justice Ouseley's reasoning, he said, without needing to consider every detail of it. But the pragmatic approach of the courts in Europa Oil to the paragraph 90 proviso is unsurprising. It allowed the policy to operate in a practical way in which the proviso should not be read as automatically negating the potential appropriateness of all mineral extraction in the greenbelt. And it's uncontroversial that a balance has to be struck in the policy between the protection of the greenbelt and the importance of mineral extraction. But the balance does require proper application of the proviso itself. And had the government, as the author of the framework, wished to do so, it could have used an unqualified exception for mineral extraction. It didn't do so, and the fact that it didn't recognises that it's only those mineral extraction proposals which, and I've already identified to this court the very wide range of such proposals, which preserve the openness of the greenbelt, that will be treated as appropriate development. And all other mineral extraction proposals will need to demonstrate very special circumstances if they're to be permitted. The council now assert at paragraph 47 of its case that the project in Europa Oil was visually intrusive, and it seems apparently to seek to compare that with what it describes in this case as Darrington's own proposals for a limited extension of activity. But if I may say so, that submission is incorrect. First of all, comparisons between different mineral extraction activities on the openness of the Greenbelt is futile, and it's not something that this court would want to engage in anyway. Secondly, the proposals aren't in any way comparable. On the facts, Europa was a proposal for 0.79 of a hectare on a temporary period of 18 months. In this case, it's 6 hectares for 7 years, with consequential activity, or the removal of the 2 million tonnes of aggregates. So I think insofar as Europa is prayed in aid or of any assistance in this court, it's very limited, merely identifying that there will be circumstances in which certain forms of development, mineral extraction development, will be appropriate in the Greenbelt. And I've identified, as I say, the very wide range. And it's unsurprising that, for example, mineral development, which is virtually all underground, has no effect on the openness of the Greenbelt. I was just taking, I think, the court, if I just need to sort of go back to, in the short time I have, to just deal with some of the other points, if I may, in relation to the council's case. And I think I'll do that by reference to a number of headings, if I may. Because I also need to say something about issue 4.
You haven't got a great deal of time left, Mr. Villard, because you started very early.
I wasn't reckoning on being, I thought I was going to be able to run up to 3:45.
No, you have the exact time for which you've indented, and as...
I think I'd started 5 minutes earlier than I had.
Yes, but no, you started more than 5 minutes earlier. Miss Ogley was very brief in her submissions.
My lady, would the court give me till 20:45 to conclude my submissions?
If you must.
I'll try and be shorter. Just remind me that 10 minutes time we'll deal with. In light of the way the argument has gone, I don't feel I need to deal with the contention of the council that visual aspects of openness are distinct considerations which are not, as a matter of law, required to be considered in every case, because it seems to me that argument is considerably narrowed. But I should just add one point, and that is that Lord Justice Lindblom did conclude, contrary to what is said by the council at paragraph 49 of his judgment, that the likely effects on the landscape, based on the likely effects of the landscape, visual impact was quite obviously relevant to its effect on the openness of the Greenbelt. I just give you the reference and I say no more about that, but it was clearly something that and that is shorthand, of course, for Creed NZ, Mr. Justice Cook. I should also say, notable, notwithstanding the great emphasis that's put on this by Lord Justice Lindblom and by the first and second respondents in their case, there has been no explanation by the council as to why bunding and planting would not be potentially relevant to the issue of openness and why it wasn't dealt with. Particularly because that adverse effect was identified by the council's officer itself in another section. But there was no read across either. I don't think I need to say anything further about the council's, the Court of Appeal's alleged legalistic approach to the consideration of openness. I think that's an issue which I've already dealt with. The council say its approach is supported by the Turner case. And could I just draw attention to the council's paragraph 66, please, of its case. Where they say in terms, the decision in Turner is plainly correct. Now, there's a certain amount of rowing back from that position later on in the council's case, but I would like just to remind the court to what was said by the court in Turner at paragraph 26, where they said that Mr. Justice Green erred in Timmins in taking the Heath and Hampstead Society case to provide authority for the two propositions he sets out at paragraph 78 of this judgment. One of those propositions included the proposition that there's a clear conceptual distinction between openness and visual impact, and yet in the council's case before this court, as I've already drawn your attention to, they note that the Court of Appeal's approach is unwelcome, it says, is unwelcome in that it tends to obscure the conceptual distinction between openness and visual impact. Thirdly, the council maintained in paragraphs 100 to 101 of its case that visual impact was not an obviously material factor on the facts of this case. And I have drawn your attention, I'll just give you the paragraph numbers, 10 and 111 of our case, that the expansion was not limited in the way that is suggested by the council. It was a substantial expansion, and that's demonstrated from the plans that have been put in and the description of the development. The council complained that Lord Justice Lindblom failed to grapple with the appellant's exercise of planning judgment. See, it's paragraph 97 of its case.
Paragraph, sorry?
Paragraph 97.
97, thank you so much.
That is incorrect, because at paragraph 49 of his judgment, Lord Justice Lindblom reached the clear conclusion that on the officer's own assessment of the likely effects of the development on the landscape, visual impact was quite obviously relevant to its effect on the openness of the greenbelt. And we make the point in paragraph 110 of our case that the phrase obviously relevant is a clear synonym for obviously material. I think I have covered all the points that I need to cover in relation to the council's case, and that therefore just brings me to deal with issue 4, which is our complaint, not accepted by Lord Justice Lindblom, in relation to paragraph 7.122 of the officer's report, which if I invite the court to turn to yet again, 372. The first point to note is that, you've got my submissions about it, doesn't include visual impact, but what it purports to do is say that, explain that it wouldn't affect openness because it's considered that the application site immediately abuts the existing operational quarry. It would not introduce development into this area of a scale considered to conflict with the aims of preserving the openness of the greenbelt. It's firstly a very surprising, well, I say surprising. In fact, it's extremely difficult to follow what is in fact being said here. This isn't a question of scale. The test is whether or not it preserves the openness of the greenbelt, not whether it would introduce development into an area of a scale considered to conflict with the aims of preserving the openness of the greenbelt. And what it's effectively doing is diluting the test. But apart from anything else, the comparison is obviously incorrect because the approach of the members is explained in 2.37 of the officer's report at page 296, where it was explained that two baseline scenarios to assess the potential impacts of the proposed development were undertaken. The first baseline scenario addresses the continued operation of the quarry to the north whilst the extension area is worked. And the second scenario assumes in the baseline that the existing quarry to the north is partially or fully restored. In particular, it assumes that either the quarry is at some point in the future fully restored in accordance with the agreed scheme and permissions granted for the extension area, which requires the site access and working area to be re-established, or the quarry to the north is restored except for the site access and the working area which is left in its operational state pending the commencement of the quarry extension. It's considered, it says, 238, that the applicant's proposed development would operate under the second future baseline scenario whereby the quarry to the north is restored except for the site access and working area. So it's nothing to the point that the development is proposed abutting an existing operational quarry. In fact, the assumption has got to be that the existing operational quarry is no longer there. So it is a non sequitur and on any basis fails to take into account a relevant consideration. My lady, and we say that alternatively is another example of a consideration which will lead to death by 1,000 cuts, because if it was the case that one could simply say, well, I'm locating this development next to other development in the Greenbelt, it's already there and it's of a smaller scale than that development. I mean, that would simply be a charter for development to be accepted as having no impact on the openness of the Greenbelt. My lady, those are our submissions.
Could I just ask you one thing which is puzzling me in relation to PPG 2, which we were shown, which one gets at MS, is volume 1, tab 15, MS 936. and I'm not sure where they deal with mineral development. And we see there that the question of openness doesn't come into the criteria for mineral development at all. There the test is provided high environmental standards are maintained and the site is well restored. And it's only at 3.12 when we get on to engineering operations where we get this thing about maintaining openness. You see that?
Yes.
Now, in the end of policy we're looking at now, they sort of brought it all together with a sort of general proviso about openness, which is brought in an application to minerals as well as engineering operations. I mean, are you suggesting that the policy has changed as a result, or there's an intention to change it? Because under PPG2, this whole debate about openness simply wouldn't have arisen.
There have been changes.
Yes, so we have to look at the new policy.
Yeah, you have to look at the new policy, and I think, from memory, this is dealt with by Lord Justice Richards and Timmins in the Court of Appeal. Could you just give me a second? Is it paragraph 33? I think it's tab 11 of the authorities bundle, page 887.
Yes. But it may not matter. I mean, we have to...
Yes, I do not accept that reference to PPG2 justifies a different interpretation. It's striking that paragraph 3.12 of PPG2 contained a general provision concerning material changes of use, which is not to be found in the framework. It's impossible to say, however, whether the omission of such a provision from the framework was deliberate or unintentional. The absence of reference to it in the impact assessment is not conclusive, and even if it's not unintentional, there's no proper basis for reading the provision into the framework. If there's a material omission, the right course is for the Secretary of State to amend the policy, not for the court to adopt a strained interpretation of the policy. I mean, that...
I see. Well, I think
it's not, it has been brought up in the context of material changes of use.
The other question, which I didn't really get an answer, Mr. Kalinsky, what engineering operations might be covered by this? I mean, can you think of any engineering operations which would come within?
Well, I mean, if I was, yes, I mean, I could... building a golf course, building...
yes, I see.
Roads
and things, and they would generally not...
drainage schemes, so, for example, in particular...
A golf course is a good example. You can think of a golf course which generally wouldn't, but if you had a great driving range, it probably would.
Yeah.
I see, okay. Thank you.
Okay. Sorry, yes, I was going to say drainage schemes, which require...
Yeah, thank you.
Thank you. Mrs. Strawn? Mr. Kalinsky.
My Lady, my Lords, in brief reply, I think there are 5 quick topics that I would like to cover. The first one is a very brief response to the contention in relation to Mr. Village's submissions about, as he characterised it, changes in the case. In our written case, we do say, paragraph 102, that visual factors were in any event taken into account, and I would ask the court to just note the content in particular of 100 Roman 10 MS51, and also when dealing with the officer's report, paragraph 12 Roman 14 on MS25 in our written case. I would also draw attention to the fact that the third respondent in its written case at paragraph 55 MS107 also made much the same point. But more fundamentally, if one goes right back to the beginning of this case and looks at the High Court's skeleton argument of the council at paragraphs 23 and 24 on page 556, the point that's made there is that it's just unrealistic to contend that visual impacts were excluded. And that is, I would respectfully suggest, very, very close to the primary basis on which the case has been advanced orally in this court. In between there were the argument got blown around by, for example, references to Creed NZ and the particular approach that was taken by the Court of Appeal. But the basic proposition that, reading the officer's report, it's wrong to allege that this consideration was excluded, I would respectfully say was right at the initial response of the council to these proceedings in misleading skeleton at paragraphs 23 and 24 in the High Court. So that's my first topic in reply. May I then move on to just make 2 points in respect of my learned friend Mr. Village's reference to Mr. Vendy's submissions on behalf of Samuel Smith and the objections. And you'll recall that he took you to the points made in relation to openness in the letter at MS 489. And the question was asked as to whether these were analysed in the officer's report. And I think it was my Lord Sales that asked the question, and I think had in mind the passage of the remediation analysis that did refer to the question of impact on openness being made in the representations from Samuel Smith. There's one other reference that I would like to just remind the court about, which is MS 373 at paragraph 7.125, where in the context of the purpose of the alleged conflict with the purpose of the green belt in assisting urban regeneration, that very letter is referred to in the analysis, which I say on a proper reading of the officer's report is connected to the conclusions on openness when one thinks about what's said in 7.126 due to the restoration of the temporary quarry and the fact that it's considered the proposal doesn't conflict with the aims of the green belt. It's considered that it does not materially harm the character and openness of the green belt.
So is the response from SSOBT, is that the...
That's that very letter. That's that very letter, my lord. So it does come into the critical part of the analysis. The other thing to note factually is those 2 letters did not criticise any analysis from the appellant counsel. They were critiquing a document that's actually not before this court, the planning statement of Darrington, which adopted a materially different analysis to that which is contained in the officer's report. And actually, chronologically, there was a 3rd letter from Mr. Vendy at MS 505 in February 2016, after the publication of the officer's report, making some points about the officer's report, but saying nothing about the Greenbelt analysis. So that's the second short point. My third point is a slightly longer point, but I hope I can deal with it very briefly, which is my learned friend Mr. Village relied upon, in particular, the analysis in paragraph 11 and 42 of the Court of Appeal, where Lord Justice Lindblom collected together elements of the landscape objection and then went on to find that they weren't sufficiently analysed in the Greenbelt section, and on his analysis there was an exclusion of analysis. May I just deal with those in this way? I would respectfully suggest there are 4 categories of landscape issue that feature in this case. One is the first one is the visibility of the operational face. So the visibility of the mine in its operational phase, and that is a factor where there's some discussion about it being visible above the ridge line, as you'll recall, but that is necessarily of a temporary nature. So the analysis of the temporary nature and the restoration in the Greenbelt section must be a response, in part at least, to an understanding of that proposition. The second category is points about landscape quality and character, which feature largely in the quoted passages. They are irrelevant to a Greenbelt analysis. The third category is the complaint, you'll recall, about the topography of the restoration, that it's not effectively putting it back to precisely the same topography. Well, the planning judgment in the officer's report about remediation is very clear, it's acceptable, and I reiterate that an observation made by the court that it might not be as nice an open landscape, but it is an open landscape. So that was expressly considered, and it's very clear what there is. Now, that just leaves, as I analyse it, the bund. And you'll recall the focus of the complaint in relation to the bund is primarily one of the reduction of views. It is a moot point as to whether that actually is properly analysed, an issue that's got anything to do with openness. As I said in my opening submissions, if one puts a forest where a field was, one will reduce the views, but one will not reduce the openness. But in any event, on any...
And there's a hedge there anyway at the moment.
Well, yes, I mean, and overall, in terms of the analysis that is a minor visual impact, if relevant at all, and it's clearly understood because it's recorded there. But over and above that, in fact, if one goes to the officer's report at paragraph 743 on MS 358, and I don't in any way place my argument as dependent upon this, but I just reflect my understanding on instructions of what the position is understood to be. The very last sentence of 743 MS 358 records that the draft section 106 also includes controls over proposed bunding measures on the site. So the analysis actually is that this is in the remediation scheme. Now, I don't want to take undue time on that, but my understanding, if one goes to the 106 that was actually secured with the planning permission, which is at MS 78, I would just call attention to the following paragraphs that I say are consistent with that analysis, and that is, it's in Schedule 3 on MS 78, and it's paragraph 1D, which is the minimisation of the visual impact of the site and integration as far as possible with the surrounding countryside, and then also C and D, which relate to measures for the treatment of the quarry face and arrangements for site contours at an appropriate stage of quarrying. And I would respectfully suggest that those provisions are broad enough on a proper construction of them to include the bund within that. And as a matter of schematic, this is capable of being dealt with in the remediation scheme. There's no challenge to that as an approach in this, and it's absolutely clear that the remediation scheme was expressly dealt with in the analysis of openness, not just in 7126, but explicitly in 7126 of the officer's report, but also in the analysis of purposes in the preceding sections. So that's the third of my 5 short points. The fourth is just to respond expressly to my learned friend's reliance on paragraphs 45, 46 and 47 of the Court of Appeal, which you'll recall is where in 45 they look at 7122 on its own, and then they ask themselves, is there anything else in the following paragraphs that means that it's not a purely spatial approach that's taken? And I have 3 points to make in relation to that paragraph. The Court of Appeal failed to draw upon the fact that the conclusion in 7126 is expressly linked to the analysis of the purposes as part of the openness conclusion. Lord Justice Lindblom doesn't refer to that. He simply says there's nothing remarkable about the analysis of purposes, but he fails to take account of the fact it's actually expressly linked back. Second point is he doesn't deal at all with remediation in his analysis, which again is expressly part of the analysis in that part of the officer's report. And the third point is nowhere at all, there or anywhere, is a recognition of one of the most important points in Europa, backed up by Lee Valley, as I said in opening, of what it is you see and the purpose of it being relevant to the judgment on openness. Now, that's something that's plainly there on the council's analysis in the relevant part of the officer's report, but isn't there in the Court of Appeal's analysis of it being defective. And then the final point is just to I probably do no more than echo a point that was already made from the bench, but there was, I'd respectfully say, a revealing exchange as to what Mr. Village's formulation of openness is. So, as I understand it, openness is an absence of any development assessed spatially, visually, or by virtue of activity. Now that, as my Lord Sales pointed out through the questions and probing, that is not a workable framework for applying paragraph 90 in a sensible and practical way, where the proviso doesn't swallow the starting point and it makes sense for the mineral extraction facilities that are commonly encountered. That is worlds away from the workable guidance given by Mr. Justice Ouseley in the Europa case. And I respectfully say this council, my client council, did not err in having regard to those considerations, but the respondent's case and the Court of Appeal's analysis did err in leaving out of account that critical insight into what preserving the openness must mean in order for this proviso to give sensible guidance in mineral extraction cases. Less I can assist, those are my submissions.
I did early on say it would be quite helpful to know when minerals were brought into female policy. I mean, if that can be done easily, it would be quite helpful.
Yes, can we take that away, work out what we can find out and try and agree a position to submit to the court as quickly as we can?
Well, so did my lady, I'd be very happy with that. Yeah.
Thank you. Well, thank you. Thank you, everyone, for their submissions, which we have read and listened to with great interest and enjoyed looking at the pictures as well. Could certainly have benefited from some of them being in rather larger scale. Those of us whose eyesight is not what it was, but it's good to have seen them. And thank you all very much, and we will now go away and try and work out what we think the answer is and let you know in the usual way. Court will now adjourn.